style spreadsheet site.
Yeah.
We are live. Good morning. It is April 10th. In Senate Economic 11th, April 11th, Senate Economic Development, Housing and General Affairs. We are taking a brief look at 687 as it's considered in natural resources. Next week, we anticipate natural resources will take a vote to combine our bill S311, H687, and their other process and land use map bill S308 into a one bill, and that we will have a back and forth with natural resources and the two money committees and the full Senate after that. So we're getting a high level overview, and we will take up that bill that's combining those other bills on Thursday. So we have Ellen for Thursday. Thank you, Ellen. You are a precious resource.
Didn't know that either. Okay.
Will we?
Learning so much
I know,
today.
right? Will be
Come by more often.
hopefully it's on your calendar. So we are looking. We're looking at whatever Ellen tells us to look at.
Madam Chair, just
I don't-
before we begin, can I just clarify, are we meeting this afternoon?
We are not meeting any afternoon anymore,
Oh, okay.
because 687 is going to be. I don't want us to get too deep into 687
Got
before Natural Resources finalizes their bill that combines all the bills on Monday.
Okay.
Okay, Ellen, thank you.
Ellen Tchaikovsky, Office of Legislative Counsel. I'm here on H687. I guess I don't totally know where to start. H687 as passed by the House. That document is available. There's also a section by section summary and a timeline. Well, there's two timelines, but it's a document with a timeline. And the first page of the timeline is the tasks of the bill overall, and then there's a second timeline that shows the updated process that the Regional Planning Commission will be following in their adoption of regional plans.
Okay,
So those are the documents.
can I, Magali, I know I would like a copy of H687. Okay, so others do too.
I would love one.
Yes. We're not gonna, yeah, so people can take it home and read it before bed.
Would be a bad idea.
Yeah, and then.
And hopefully sleep with it under your pillow, so you just absorb it by osmosis.
Okay.
I wish you
Back
had
to
told me
Ellen.
earlier.
This is quite long, the document, so it will take a while.
Yes.
Obviously.
So really what we have time for the section by section, which at least helps us understand the big buckets of things in here.
Sure, so broadly, I'll start by saying that this bill combines the three reports that came out, the necessary Act 250 updates, the regional plan, then it goes into the Regional Planning Commission updates, followed by the designated area updates. And then there's a couple other topics in this bill, but it's all related to land use planning overall. So the first 18 sections actually are about professionalizing the Natural Resources Board and renaming it the Environmental Review Board.
Okay.
So that's the first page. So first, there is a session law purpose section that outlines sort of what I just explained. Next is a statutory purpose section that's being added to Act 250 to add references to the capability and development plan, the municipal and regional planning goals, and the 30 by 30 and 50 by 50 goals.
Okay.
Next amends the NRV statute itself, renaming the board to the Environmental Review Board. 5 members appointed by the governor based on a list provided by the Environmental Review Board nominating committee. And so I will say that these sections 1 through 18, 17, 18 have passed and been sent to the governor twice and have been vetoed. So this is language that you have seen and passed before. There's very minimal changes that have been made to it. One of the changes is made in section 3 is that this language builds out the requirements or the skills and expertise sought for members of the Environmental Review Board. And previously it had added not only just environmental and land use planning law, but also community planning and environmental justice. And it specifically called out that all candidates shall have, a commitment to environmental justice, so. A small change, but, reflects some of the other work that's going on in this bill. Next, so the Environmental Review Board Committee is being established. This is a committee that's it's nearly identical to the Cannabis Control Board Nominating Committee.
Okay.
And it's similar to the traditional nominating board. It is made up of 6 members, 2 from the executive branch, with 1 being from the Department of HR, 2 members of the House, 2 members of the Senate, who will post the vacancies and then interview the candidates to compile a list. They're supposed to be appointed this summer so that they can help the nominations happen as quickly as possible. Section 5 is the rulemaking section in statute, so it directs the board to adopt rules of procedure for hearing appeals, approving regional plans and regional maps. And so this is part of the overall sort of synergy of these 3 reports. The regional plan report came out and is going to provide a whole series of sections related to providing uniformity and consistent use of terms in regional plans. Those plans will then be reviewed for approval by the Environmental Review Board. Currently, all regional planning commissions have adopted regional plans, but there's no overarching oversight of those plans. There's not currently a review body to do that. So this is providing a level of oversight to the regional plans and the regional planning commissions, and that's discussed in greater detail later in the bill. Section 6 updates the duties of the Environmental Review Board to add those same tasks, which is hearing appeals and the regional plan and regional planning maps. Section 7 is about personnel for the board, specifically making permanent the position of executive director. There currently is an executive director. He's in the room. Currently, that is a limited service position that's funded by ARPA dollars. And so this is a directive that position should be permanent.
You're kidding.
I'm not kidding. It's an interesting history on that.
We don't have time for it. But I just want us to get to section 18 before we ask any questions.
Section 8 shifts the burden of who provides notice of applications. So currently it's on the applicant, but now the district commission will be providing the notice and posting it on the board's website. Section 9 tracks references of appeals going to the environmental court. And then section 10 is a big section along with sections 13 and 14. And so I think I already briefly touched on this, but one of the primary tasks of the board is hearing the appeals of activity permit decisions from district commissions at the board level. And so this happened for about 30, 40 years previously. The appeals of Active 50 permit decisions went to the board until 2004, at which time it was moved to the environmental court. And so this would be moving it back. So it has the procedure. It largely is copying the exact procedure that is in statute in the environmental court's statutes, but it's moving it to the board's statutes. It's also giving them authority in section 11 to hear appeals of jurisdictional opinions from district coordinators. Section 12 establishes the fee for these things. So filing an appeal, application for tier 1A area and regional plan maps all have the same fee, which is $295. $295 is the current fee at the environmental court for filings. So it's the same amount. It will not cover costs.
No, he's supposed to do that.
Okay.
Sections 13 and 14, as I just mentioned, remove all the references to the environmental division hearing Act 250 permit appeals. Section 15 is the appropriation. So it establishes 2 new attorney positions for the NRB. It also does establish that there will be 4 part-time members of the board. The chair will still be a full-time position. The other 4 members will be part-time Currently, they just get per diem, so those positions are not state government positions, so it's making them part-time positions. But since they are not scheduled to start and be appointed until July 1 of 2025, there's not an appropriation for those members. There is an appropriation of $112,500, which would cover approximately half a year of 2 new attorneys starting at the board, and so that's the number there. Section 16 transfers the personnel from the NRB to the ERB. Section 17 sets the deadline of when the appeals will transition from the court to the board. It's set at October 1 of 2026. And then section 18 is the revision authority. So you can see this on your timeline, but the members of the board are to be appointed before July 1, 2025. They'll then take over and begin drafting the rules of procedure for the appeals. And then they'll have 15 months before the appeals actually are heard by the board.
Okay. I think the best thing to do now would be to stop and ask questions about these 18 sections. You're fine.
I was in the building.
You were
at
fine.
8:30, But I was ambushed in my committee.
I am feeling ambushed a lot as well, so I understand.
Something about money.
Yes. So,
Well, not all the ambushes.
questions on the first 18 sections?
What has to be run over?
Yeah, that's the
So-
question.
There are lots of other things in E-court.
Well, let's let Ellen.
Yeah, I agree. The environmental court existed for 15 years without hearing Act 250 appeals. So they currently have between 10 and 15 Act 250 appeals per year. And I think the zoning testifies that is only a small portion of their overall docket.
Small.
Compared, I mean, they also hear municipal permit appeals as well as all the ANR and other
We aren't sending any money there.
No, right, it's not like we're getting rid of it.
Oh.
We never close anything.
Right.
It is a portion, I don't know the exact percentage, but it's less than 15 a year out of the rest of their docket.
Okay, Senator Clark.
But to your added an additional E-court judge,
I do,
Right.
that might be money that we can, if we move ahead with this construct, that might be money we can liberate for other things.
It might be, the problem is it was a Superior Court judge and they probably need a Superior Court
Yeah,
judge.
it's true,
anyway.
they do, and it's being asked for. now.
Senator here.
Just, I appreciated one court looking at both the municipal and the Act 250 appeals because they often have the same aspects and it's the same situation. So I think that's a disadvantage of doing it this way.
You mean one set of eyes, but.
Right, right,
look,
right.
our committee said-
Well, it's the same situation
Mhm.
The
that gets
question is what
appealed.
happens if the two bodies come up with the same general issue with two different opinions that are
That's
opposite of one
true,
another.
right?
That may have been
Right.
discussed.
You have to get
Was that
the Supreme Court-
discussed?
So- It has come up before, not that it can happen now. There is a process currently called consolidation of cases, and there's also a process of coordinating cases. When the appeals first were sent to the environmental court, there was an idea that they could consolidate an Act 250 case with an associated either ANR permit appeal or municipal appeal. And the data shows that that rarely happens. It happens perhaps once a year, perhaps less, because it is actually a really complicated process to combine two different cases that may have two entirely different sets of parties. They do more often coordinate to make sure that the timelines on either appeal set don't conflict or make it difficult, but that is not necessarily. It is not the process that was originally envisioned in 2004. That process is actually rarely used. So there may be some advantage. Also, these are different sets of bodies of law that can result in legal decision differences by those judges already.
Right.
I have other questions.
Can I add one thing?
Yeah.
The House budget has in it 3 judges for the Superior Court. The Senate will review that, but that
Mhm.
is part of the overall package
Right.
also.
Yeah, and I don't think we can it's up to us to take that judge away and put that money.
Yeah, no, just saying that.
Yeah.
Money we can, and support we can throw towards the judiciary request.
I'm not understanding if the new environmental review board is asked to hear new sets of appeals before they have a new professionalized membership.
They are appointed in July of 2025. They will not begin hearing appeals until October 1 of 2026.
Okay, so we haven't, okay, so that is,
It gives them 15 months to
Mhm.
develop their rules, get more comfortable in their position
okay,
before they start hearing appeals.
okay. With the section 6, supervisory authority of the board and district commissions. Does this give the board more supervisory authority over the district commissions?
Section 6? No,
Yeah.
no,
Okay,
I mean, that exists already.
okay.
And I think there is a hope that by having, 4 other
Mhm.
members employed at the board, that there will, and combine, so this isn't adding additional authority in that way. But there is, interest in having, now that the board will be hearing appeals, they will have direct knowledge and, ability to review holistically issues that are coming up in the Act 250 program that they can then use, to train district commissions and district coordinators in response to their decisions.
Okay,
Uh,
and there's per diem for section 4 for the nominating committee?
Yes.
Okay. The section 10, it says appeals of board decisions go to the Supreme Court.
Yes.
Does that, when it says appeal to Supreme Court is limited to objections raised, that means that the tiered maps are not subject to this appeal?
The tier 1A, so that tier 1A has the ability to be appealed, tier 1B does not. And the tier 3 process is not finalized, it'll be a rulemaking process.
Okay, but tier 1A, it's specifically written into the language here that T1A could be appealed to the Supreme Court.
Yes.
just Supreme Court bypassing E court.
The designation of this tier,
From the board to the Supreme
Yes, from
Court.
the board to the Supreme.
and that's a one-time designation, it's not recurring.
It is recurring.
The 1A,
Those were all my immediate questions on these sections. I'm not raising my concerns right now because we could do that together next Thursday.
May I just ask
Mhm.
one question, just because you mentioned it? The fee is the same, the filing fee in section 12. It strikes me that fees are designed to cover the cost of things. And what is the cost of,
They don't know yet.
right, that's true, but there was no speculated cost for that, okay.
Okay.
It just. It's like,
I think
there's
it's
lots of questions.
in the next 7 minutes, I think we should try to get through the next, up to section 27.
So sections 19 through 22 add a new forest block and habitat connector criterion to Act 250. So you will recall that there are currently 10 criteria which a permit application has to address. So it's adding a forest block and connecting habitat criteria so that the application should have an undue adverse impact on forest blocks and connecting habitat. And they should avoid, minimize, and mitigate impacts to those forest blocks and habitat connectors. There's rulemaking with that as well. Section 23 is lowering the primary agricultural soil mitigation fee for wood products manufacturers to 1-to-1. Currently it is between 2-to-1 and 3-to-1, so this is lowering it. Section 23A is an entirely different topic. It was a floor amendment. It adds, changes the definition of accessory on-farm business. And then it allows that, this is a really complicated, deep legal concept, so it's actually not, it is not Senator Starr's language at all. It is an entirely different version from the House, but he does have a bill that he has been interested in. So this would allow them to, the business itself to exceed the revenues of the farm, allow them to sell merchandise and agricultural products grown on other farms and baked goods, which I forgot to mention there. And then section 23B creates an exemption for these businesses from Act 250.
Legally,
Well, there's details. So it exempts all businesses that are doing storage and sale of products. And then there's a exemption for preparation and processing, so long as 50% of the products come from the farm where the business is located. But then there is no exemption for event spaces.
so events aren't exempt, just business activity.
Not from Act 250, no.
So if they're putting up a huge arena, that could trigger.
Yes. Section 24 is the road rule. It is an 800-foot road rule and 2,000-foot road rule starting July 1, 2026. The one that it is similar but has slightly different language than the one you passed, which was 1,000 and 2,000 foot. And then there is the ability for the NRB to adopt rules to clarify some of the elements of the road. Section 26 starts the language on the location-based jurisdiction of the tier system. So it creates the jurisdictional trigger for tier 3 and the definitions of tier 2 and 3. The definition of tier 3 are areas with critical natural resources, which may include river corridors, headwater streams, and habitat corridors of habitat connectors of statewide significance. But there is a rulemaking section that directs the NRB to provide specifics of the definition of what are critical natural resources that should be included and how those resources will be mapped.
How is tier 2 defined?
Anywhere that isn't tier 1 or tier 3.
It's like my pet issue.
Yeah.
I just hate that so much, but that's a me problem.
No,
No, that's.
I think it's a general
Yeah.
challenge.
I mean, I think that when you, I disagree. I think that that is what it is, unless you create another tier, because
Mhm.
the entire state has to be covered.
Yes, I don't wanna
So-
say tier 2 doesn't exist, I wanna say there are different types of tier 2, or we're getting more specific about what can or can't happen in tier 2. I don't wanna fight about what tier 2 is with natural resources for the rest of my legislative life.
Okay, so next is tier 1B. So under this bill, the Environmental Review Board will be reviewing regional plan future land use maps. So the regional plan itself and the future land use maps, which are going to be discussed in greater detail in the later sections. And part of that will be tier 1B. So the application for tier 1B will sort of be automatically part of that process. The municipality has to submit documentation that they want to be designated as tier 1B. And so it happens with that process, and that decision is not appealed. Sections 28A, B, and C extend the sunsets from last year, the exemption sunsets from Act 47 to December 31st, 2026. And that's because the tier 1 and tier 3 are envisioned to take over January 1, 2027. So it extends those exemptions until the new tier system is to take effect.
And I will just say that the Natural Resources Committee knows that this is one of our biggest areas of concern, is what exemptions are in effect and what the timeline is for that.
Section 29 establishes the process and criteria for tier 1A designation, area status. Municipalities are allowed to begin applying January 1, 2026, but they cannot apply until their regional plan has been finalized by their regional planning commission. So it might not happen that early.
Given they have to be done by December 26th.
Yes.
So they have an existing plan that's still valid, that doesn't count.
Well, it won't address the required elements that are necessary to meet these things.
Okay.
And so, yeah. The ERB's supposed to issue guidelines for municipalities applying for this by January 1, 2026. The towns have to identify on their town maps their tier 1A, tier 1B areas. And then section 32 are the exemptions for tier 1A and tier 1B. So full exemption in areas that are tier 1A areas and from Act 250, and in tier 1B up to 49 units of housing, including mixed use development housing. Section 32 also has 3 exemptions that are in S311. Exemption for hotel or motel converted to permanently affordable housing, accessory dwelling units, and then converting a structure from commercial to 29 units or fewer of housing.
Okay, now let's, this is 9 o'clock.
Yeah, we have to
Oh,
go.
yeah, sorry, I could do this all day. Thank you, Ellen, we've made progress, and people now have a copy of the bill, so if you flagged a section you're concerned about, I would at least read that section. When we have Ellen back tomorrow, we'll finish the overview, we'll see what we get to, and we have Ellen then next Thursday, and I know she's coming Monday. Well, you're coming in Monday anyway, but you're helping Natural Resources on Monday, so we appreciate how much the time you are giving us.
We do.
We will not be live for this. We are listening to Tourism Day. And so it's not on our live stream. I don't know that they
It's
have
not
the
somebody else.
legislative, they don't have the legislative capacity for live stream. So none of us are discussing legislative business. We're just listening to our tourism stakeholders. And then back.
It's in the pavilion.
For an introduction of 707.
Okay. It's
The video program.
I think
Yeah.
after the fact, but there's no live
After
stream,
the fact, that's right.
something like that.
I'm gonna check off